Ms. Ruhtenberg.
Thank you, Your Honor. May it please the court. Counsel. My name is Maria Ruhtenberg. I am here on behalf of Mr. Harris. He was convicted in Woodbury County of assault with intent to inflict serious injury and going armed with intent. Today, we are asking the court to reverse his conviction for going armed with intent. And we're also asking alleging that the district court abused its discretion in sentencing Mr. Harris to consecutive sentences. This all started back in 2013. My client went to a bar in Sioux City and was playing a pool with another fellow in the bar named Niles Chance. At some point in the evening, there was a disagreement about the pool game, an allegation that Mr. Chance had cheated, and an argument ensued. The bartender described it as raised voices. The bartender said, "Keep it down, guys," and then they went on and were continuing to argue. So the bartender said, "You know what, enough is enough, I'm closing down the bar." My client left. Mr. Chance and my client's girlfriend stayed back in the bar for 4 to 5 minutes, and then they left, and Mr. Harris was outside the bar at that time, presumably waiting for his girlfriend, who was driving that night.
When you said your client left, is that the type of movement that the crime anticipates?
I'm arguing, and our position is that the assault happened outside the bar. When he left, there was no evidence of any intent of him assaulting Mr. Chance. There wasn't an assault in the bar. There wasn't any aggression. There was raised voices and a disagreement over the pool game. Once he's outside the bar, he was standing there, so he wasn't moving. There were some words exchanged between the two of them. They have different versions of what those words were. Then, according to Mr. Chance, he turned to leave, and that's when my client allegedly stabbed him. There wasn't any evidence that there was any movement once that altercation outside the bar happened.
Do you agree there was substantial evidence, or a reasonable jury could infer that he had a knife at the time he was in the bar playing pool?
Well, yes. My client denied. He testified he denied having a knife.
Well, it didn't come out of the sky, I don't take
Right,
it.
and we haven't challenged a sufficiency of the evidence on that ground.
And then why couldn't the jury infer then that he walked out of the bar planning to strike and assault the other individual, Mr. Niles, as soon as he left the bar?
Well, I think that would be speculation. As I said, he was with his girlfriend that night. She was his ride. She testified that she drove him home, that she was intoxicated and shouldn't have been driving. There's equal speculation or equal evidence that he was waiting for her, as he had no other way to get home other than, I assume, walking. So there wasn't anything in the record that indicated that that's the reason he left. Nobody testified that, I'm going to wait for you outside, or just, anything that indicated that he was planning an attack on Mr. Chance. The altercation happened outside. Both of them testified that pretty much by the time they got separated in the bar, there wasn't really any fighting going on. That the bartender had pretty much cooled off at that point. And then it heated up again when there was words exchanged outside the bar. And at that point, even taking Mr. Chance at his word, there wasn't any movement. It was a disagreement or some words exchanged, a fight. They went to the ground, there was a knife, and then my client left. So there wasn't any pursuing. The Iowa Court of Appeals stated in its opinion that once, at some point during this altercation, Mr. Harris lunged at Niles Chance. And I read the entire transcript yesterday, and I can't find where the Court of Appeals found that information. Nobody testified that there was any movement or lunging or anything like that.
Isn't it just the jury's, it's fair and reasonable for the jury to infer that that's what happened, even if they're having a discussion a few feet apart, and then somehow he ends up getting stabbed in the back of the head. There has to be a natural lunging or some type of movement from that location to another location. The guy didn't assumably didn't go charge him or go after him.
There was the evidence that Mr. Chance testified at trial that they had some words, that he turned around, and that's when my client stabbed him. There's no evidence that he made a step. Now, maybe hitting him or stabbing him, that's motion with an arm.
But isn't that a reasonable inference that a juror could make?
There wasn't any evidence of it. There wasn't any testimony that he took a step away. There was evidence that there was the opposite, that he pushed him against the wall. So there was actually more evidence that he was the aggressor than there was that he walked away.
I was not entirely clear after reading this as to whether did the stabbing, does the evidence, is there a dispute in the evidence about whether the stabbing occurred before the bartender came out and saw them on the ground? Is that the
Yes.
clear indication? Or it didn't occur after they were on the ground and Mr. Niles got up and started to move away?
Right.
Right.
I think Mr. Chance testified that it happened pretty quickly after he left the bar. There was some, like I said, some conversation. And then he testified that Harris hit him, stabbed him, and then they struggled and went to the ground. And that my client testified that Mr. Chance pushed him against the wall, and then there was a fight, and they went to
I mean, testimony isn't like, a witness's testimony isn't like cable TV. You don't have to take the whole package. But your client gave this kind of, one might say, not very believable statement that he never had a knife and he didn't stab and all of that. But somehow, Mr. Chance had all these wounds on the back of his head. And so, I mean, in kind of evaluating the evidence, can't we kind of assume that the jury probably credited, for the most part, the victim's story?
Yeah, I agree with you. I think even if we take Mr. Chance at his word, and just to regard my client's testimony, I mean, it was different testimony about what happened before the bartender opened the door. But even if you take Mr. Chance's testimony as truth, once they're outside the bar and this altercation took place, there was no movement required to, for the going armed with intent, that he didn't have the intent of stabbing him. I mean, we don't know what the knife was. It could have been a pocket knife that this man carries with him all the time. The evidence was that he went to the bar to pick up a friend and ended up staying and playing pool.
Well, let's step back a little bit and take a look at what do you think the legislature contemplated when they enacted this law? When they said that a person who goes, it's kind of, I don't know, but so a person who goes armed with a dangerous weapon with the intent to use it for someone else, what protected interest did they seek to accomplish, and how did they think this crime was going to fit into society?
I think that if you look at that crime, in addition to our assault statutes and our carrying weapons statutes, those other statutes cover a lot of this kind of situation. It seems to me that this law was aimed at protecting people from saying, if the facts were different and my client says, I'm going to go down to that bar and I'm going to get Mr. Chance, I'm tired of him cheating at pool, and he goes, he gets his gun, puts it in his pocket, runs down to the bar, he's arming himself and going someplace with the intent to harm.
Okay, so if Harris had done that and he's pulled over by police on the way to the bar and he's armed with the intent to inflict harm on the victim, then he's committed the crime.
He's armed himself with, I'll read the statute again.
A person who goes armed with a dangerous weapon with the intent to inflict harm on another person without justification.
Yes, I
So
think,
if someone leaves their home or moves from point A to point B with a dangerous weapon, it becomes a crime
I think it's,
once the intent arises?
yeah, I think the intent to harm obviously is an important portion of this. and arming yourself with that intent and going. I mean, obviously you have to go with that intent in mind. In this situation, I don't think he went anywhere with the intent of harming Mr. Chance. I think there was an assault. I think that there were some words, and he did have a knife on him, if we believe Mr. Chance's testimony and disregard his.
Well, just how broad did the legislature intend this? When they intended there be some movement, because they talked about going, or it's a person who goes, so there's some movement here. And is the intent required as a part of the movement, or does this crime apply to someone who carries a weapon? They're going around society, they're moving around the community armed with a dangerous weapon. And then if in the course of that movement they acquire an intent to use it against another, is that when the crime is committed?
Well, I think it's the former. I think that there has to be that intent to harm. Otherwise, it's covered by other statutes. If it's an illegal
In State v. Pearson, we said it doesn't take a lot of movement. It was grabbing a frying pan and crossing a kitchen to hit the victim was sufficient evidence, but we held that you had to have a new trial when the jury instruction omitted the element of movement. Does that case help you?
Well, yes, I think that the only difference here is that, unfortunately, counsel below didn't object to that jury instruction. Should have. I think everybody agrees with that the instruction given was not a correct instruction. In that case, interestingly enough, they found sufficient evidence of movement because he did move across the kitchen with a frying pan, but said nonetheless the jury wasn't given all of the elements of the crime.
Doesn't that case, it probably hurts you on sufficiency, but it helps you on your ineffective assistance argument, because here you have a case of our court decided before the trial in this case where we said in a footnote you need to submit the issue of movement to the jury, right?
I think that, yes, they did find sufficient evidence in Pearson, but the facts were completely different. I mean, there was actually there was so much movement across the kitchen. And here, we don't necessarily have any evidence that he moved a step. So when we talk about the prejudice portion with the jury instruction, the fact that there is so little evidence that there was any movement at all, unlike the Pearson case.
Let's assume there was movement, and for the purpose of this question, not giving the jury instruction on movement, is that reversible error when it's raised on ineffective assistance of counsel, or is that only reversible error under Pearson when raised on direct appeal?
When it's raised on a direct appeal, obviously, with the objection and preserved error, obviously then prejudice is presumed, and so it's allowed.
So what about the argument on ineffective assistance of counsel with the standard of we don't have confidence in the jury verdict?
I think that then you have to look at the strength of the evidence. I would argue even if there's some evidence of movement, I think you still need to remand for a new trial.
Could it be a structural error that the court is determining an element that the jury should have found out, or is it something we can just poo-poo under ineffective assistance of counsel?
It's relieving the state from its obligation to prove all of the elements of the crime. I mean, this court has held that movement is an element of the crime, and when the court doesn't give the jury all of the, maybe we think that there's
But
the
defense
So can't
attorney-
we presume, so then can't we presume that there's going to be prejudice there?
I think that you can. That's certainly the standard. If it were raised, if it were objected to below, it seems.
We need to presume prejudice because it seems to me you may well have prejudice. We've just spent most of the argument discussing the issue of sufficiency. Even if the evidence is sufficient, if the verdict may be in doubt because of the failure to instruct the jury on the going element, then that may be a problem warranting a new trial.
And that's what Pearson says, and we're relying on that case and believe that the result should be exactly the same in this case, that it was error for the jury not to receive all of the elements of the crime. So we ask for you to reverse his conviction. Thank you.
Thank you as well, Ms. Ruhtenberg. Mr. Sloven?
Thank you, Mr. Chief Justice. May it please the court, counsel. So there's 2 points I want to get across in this argument. First is there's very clear evidence in this case of movement while armed with a knife with intent to inflict serious injury on Mr. Niles. The second is that the omission of a jury instruction of a required element of the crime in the marshalling instruction under the ineffective assistance of counsel rubric is reviewed for Strickland prejudice. It's inappropriate to presume prejudice or treat this as some kind of structural error when it's possible to assess.
But
the
even
impact.
if you have Strickland prejudice, here's the problem I have is the way the instruction was given to the jury, it seems to me that a jury just kind of hearing that instruction and taking it back could have just decided, well, all I have to decide is whether Mr. Harris was armed with a knife. And yeah, he was armed with a knife, and he had the intent to inflict harm. Yeah, he had the intent to inflict harm. That's pretty easy. What's more in doubt is whether, as Ms. Ruhtenberg pointed out, whether he formulated an intent back when he was in the bar to inflict that harm on the victim and walked out the bar carrying that knife while possessing that intent. And that's what it seems to me that the jury didn't get the essence of in this case. Help me out.
Yeah, and I want to answer that very fact-specific question with the facts of this case. First, I want to point out that already in that analysis, we're assessing the impact of the omission of this element in the instruction, the impact that might have had on the verdict. And I submit that it's possible to do that based on the facts of the case, or it's possible to decide that we can't assess that impact. But from case to case to case, this is trial error. It's not structural error. It doesn't mean that the state's case wasn't subjected to adversarial testing. It doesn't mean that there was some sort of denial of the ability to present the theory that none of this ever happened.
You get a jury determining the facts? You don't. I mean,
we have a jury determining some very important facts, and I submit that there's no reasonable probability that with what we know they did decide, that the submission of that instruction could have changed anything.
we don't have directed verdicts in criminal cases. The defendant is entitled to a jury verdict on every material fact.
That's true. In Hopkins, this court assessed the impact of the omission of the correct definition of operate. The jury was allowed to convict not based on a finding for OWI, not based on a finding that the vehicle was, the motor was running or it was in motion. And so the jury didn't decide whether that required element of OWI was met. And yet this court, assessing it under ineffective assistance of counsel, said, with what we know the jury found and with the evidence presented in the case, there's no reasonable probability that that could have impacted the decision if they had that additional question, that we know a lot about their decision.
Here we have an element that's entirely missing.
Well,
For the second crime, of course.
and Hopkins isn't the only case where this has happened. My point is that we have been reviewing these cases, these claims as subject to normal Strickland prejudice rules before, and this case can be done the same way.
Are there any cases after Pearson where we've done it where an element's been missing?
The Court of Appeals did in Demery.
I know our court.
For this particular crime, I don't think there has been one since
I mean,
Pearson.
has the issue come up in our court since then?
No.
But here's the concern. I share some of the concerns that you're probably voicing about just deeming something a structural error, because then you end up with reversals where the trial judge never had the opportunity to address the issue, and in effect you're relieving defense counsel of their job to be defense counsel. But help me as to why there isn't Strickland prejudice in this case. It strikes me that maybe you overachieved at the Court of Appeals. They said that because there was substantial evidence of movement, that therefore there was no Strickland prejudice. That's a different standard.
I agree with that. I think part of this is because the defendant never carried the burden of arguing why there is any reasonable probability of a different result. What I'd expect to see in that argument is some way that the jury could have convicted on these other counts and not come back with the same answer on the movement element. I really just don't see that here. Now, Mr. Chief Justice, your first question was the fact that Mr. Harris left the bar at that moment, is that enough to establish the movement element of going armed with intent? I'd say yes. If he leaves the bar armed with a knife with the intent to lie in wait, position himself to lie in wait, and attack Mr. Niles,
The
that's
jury
going
may
armed
have-
with
May have
intent.
viewed that differently, based on the record we have. I think there may well be substantial evidence, and that's what the Court of Appeals, I mean, you know, he walked out, he was looking for him, and then he's guilty of the crime. The other scenario, that's at least conceivable on the record, I think, is that he walked out without aggressive intent at all. He had the knife, I think. I mean, jury could assume that. Walked out without aggressive intent, and then ended up with a fairly static altercation in terms of movement. And couldn't a reasonable jury maybe have come up with that conclusion?
So I want to talk about what happened outside, but I only mentioned that question and that theory first to say that's something that the jury could have believed, and I think that's one of the things that the legislature intended to criminalize here is taking a weapon and positioning yourself to commit an assault, like going to a location, lying in wait. But you're right that the jury could have found going armed with intent based on what happened outside of the bar. Let's talk about Chance's testimony, because I think it was misconstrued earlier. Chance said that after they had words, he turned and walked away. That's at page 13 of the trial transcript. Another thing that he said on cross-examination is, while he was face-to-face with the defendant, he didn't see the defendant move, either in his pocket or make movements toward him, while he was facing the defendant. So either there, and he says he turned and walked away. At that point, to get to the position where he could have been stabbed in the back of the head, the defendant had to move, right? And at that point, and this is kind of confirmed by the blood evidence on the sidewalk, Chance says that Mr. Harris was standing with his back up against the wall on the side of the bar. This is State's Exhibit 10. To get from that position with your back against the wall to where the first blood spatter appears, that has to be movement. It's at least 6 to 8 feet, and it might be more. The scaling is a little different. There's State's Exhibit 11 that you can use for comparison. And there's also 2 blood spatters on the ground, indicating that there's movement during the fight between at least 2 stabbings that occurred during that fight.
The movement during the fight, the problem I have with that is if it's just one assault, I have trouble with the notion that we've had those cases like Velez that define the unit of prosecution. If it's just one assault, I have a problem with the notion that the going armed you can be convicted of that merely for being armed within the course of a single assault.
And I think
Now,
that gets,
I'm more interested in your first point about the 7 to 8 feet, and your argument, I guess, is, or 6 to 7 feet, is that's kind of like the frying pan across the kitchen. Is that what you're saying? That would be
right, exactly,
a small
that
kitchen, maybe.
If you had told this jury what the movement element of going armed with intent was, right? In order to conclude that believing if they went even substantially with what Mr. Niles described as happening, in order to conclude that any assault occurred, they would have to find that the movement element was satisfied. There's just no reasonable probability here that they could have returned the verdict that they did based on the evidence that they were given and tested against the defense theory that was presented at trial, which was, I never had a knife, there was no attack. There's no way that they could have returned a different verdict if instructed on this omitted element. And
Well, I'm going to just make a comment, and this is what's so bothersome, because I think the chief was talking about this earlier on. This is such a strangely worded statute, and just as Justice Mansfield was saying again as well, going armed with intent, can just be so innocuous. I don't know how you prove it other than in this context, and so my commentary is that it just seems to be a piling on of an additional charge, which I don't really like, because he was charged with assault with intent to inflict a serious injury, which is the actual crime that I think is committed here. But now that we have to take the statute as it's written here, which says that you have to have an element of going, and it still gets back into me and the concern that I have with the jury instruction, which doesn't follow the statute. And I still think that you're able to then almost presume that there's going to be prejudice if the state hasn't shown that as an element of the offense, which is their burden.
So there's a couple things there. One is I have another thing that I think the legislature was trying to criminalize, and that is pursuit during an assault. That we can talk about unit of prosecution on assault another day, but if the victim of the assault is fleeing and there's a pursuit happening with the intent to commit further acts of violence against that, even if we could construe that as the same assault, I think that's something legitimate for the legislature to criminalize, is pursuing someone fleeing with the intent to inflict more injury. And to go to the idea of this being difficult to prove or seeming like an innocuous offense, something more broad, intent is so difficult to prove. It's so rarely subject to direct proof. We need to prove it circumstantially through evidence of statements or actions. And I think the intent to inflict serious injury with the weapon is really what the legislature is that's the danger that's being addressed here. And that element was included. They found that he was armed with the weapon with the intent to inflict serious injury. I think that's the core evil, and that's the more difficult showing to make. I don't see any way on this record that they could have found that. They disbelieved all of the defendant's testimony that he wasn't armed, and also the defendant said that Mr. Niles didn't walk away at all after their confrontation. I think the jury's entitled to disbelieve that too. I don't think that was credible in the least. That's on page 92.
Counsel, back to just the movement analysis briefly. So it seems to me we have the two options for proof of movement that we've discussed. The one being the movement out of the bar to the outdoors, standing against the wall. The other during any movement, potential movement or proved movement, during the infliction of the wounds. And on the latter of those two alternatives, is your position based, the position that movement occurred during the infliction of the wounds, based entirely on the blood spatters, or is there some other particular factual piece supporting your conclusion that, hey, there was no other outcome, no other conclusion or finding the jury could come to but that he moved?
I think the blood spatter evidence is particularly compelling. It's physical evidence that the fight was occurring in two different locations. It's like the shell casings, I think, in Demery, if I remember correctly, that showed that he was moving across the field as he was firing. I think that's the correct case. The other evidence, again, is Chance, Mr. Niles, saying that he turned and walked away. And this is the argument that the jury was given in the closing from the state on page 121. Chance's testimony is described as he turned and took 2 steps and then was stabbed in the back of the head. Now, I want to talk really briefly about the idea, just to go back to the framework, and I've tried to, as I was recently invited to do, put myself in defense counsel's shoes. And when I look at this instruction, it occurred to me that if defense counsel did notice that this instruction was deficient, then declining to object to it, A, was reasonable trial strategy in the sense, or it could have been reasonable trial strategy not to argue this as an alternative reason to acquit. It undermines your credibility to say, you should believe my client, everything he said is true, but if it's not, he didn't move before he stabbed. It just rankles the jury, I think. But B, not correcting this error at the trial court level would provide, if we do adopt some standard where we presume that this is prejudicial, it would provide a route to an immediate retrial on the ineffective assistance claim, that the defense could roll the dice and see if they could get an acquittal.
I agree with most of what you're saying, Mr. Sullivan, but part of it I don't. I mean, you don't have the instruction conference in front of the jury, so you could object and ask for that element and then not particularly argue it as your closing argument, but it's still out there as something that the jury has to find.
Oh, I agree with that. I guess what I'd say would be the reasonable strategy in that sense is not urging the jury to use that as a grounds for acquittal, urging them to focus more on the evidence that you have presented. And I think that's another reason why this is trial error, that we can assess the competing theories of what happened that were presented at trial. We can say, did the jury believe one of these in its totality and reject the other? And I think that that's what happened here, that the jury disbelieved everything that Mr. Harris said, and it believed Mr. Niles' account of what had happened outside of the bar. And the evidence clearly showed that if this assault happened, I think that we can add the possibility of the jury finding the movement element satisfied before the assault even happened when he left the bar. We can add the possibility that they found the movement happened during the assault or immediately before the assault. I think all these things cumulatively help to demonstrate that there is just no reasonable probability of a different result.
Does the intent to use have to arise or coexist with the movement?
If it doesn't, then there's no way that the defense can win, no matter what we think of the facts of this case. I think from our reading it does, and that's our reading of Ray and Taylor. I do think that there has to be a contemporaneous intent to inflict injury during the movement element. But I submit that there's no reasonable probability that a jury that returned these verdicts would have answered that question any differently. Thank you.
Mr. Sloven, thank you. Rebuttal, Ms. Ruhtenberg?
Thank you, Your Honor. I would invite the court to read page 13 of the trial transcript. Mr. Chance's testimony, and I'll quote it. He says, "I turned right to go to my vehicle, and as I see him, I stopped to confront him and let him know there was no hard feelings and it was just a pool game. His girlfriend said something about money, then I turned to walk away, and that's when he was stabbed or punched, or he thought he was punched and later discovered he had been stabbed. It wasn't he turned and walked away, it says he turned to walk away, and if he had walked, then the prosecutor in closing says he took 2 steps. There is absolutely nothing in the record to support 2 steps. I think that's important. Maybe he turned his back, he was going to leave, and that's when my client got mad and punched him. But I think that it is a misrepresentation of the record.
What are we to make of the different locations of the blood spatters?
There wasn't any testimony at trial about the blood spatter that I remember. There was, however, an altercation, the primary altercation, and then Mr. Chance took my client and threw him to the ground.
Wasn't there a photograph of the blood spatters? I'm not sure, I'm just asking, yeah.
There was a photograph that I just looked at, it's in the appendix, and I think it's exhibit 11, 10 and 11, where there's some blood on the ground. I didn't see anywhere else, but I just looked at it as you were discussing it. So I can look at that in more detail. I don't have it in front of me right now, but.
Is there a reasonable trial strategy in this case for not objecting to the omission of the movement element?
I think that's very unlikely, given the fact that the sufficiency of the evidence on that particular element was preserved, and he did object, and he did put that as part of his motion for judgment of acquittal and argued that to the court. In addition, I think it's much more likely that they used the bad uniform instruction. The instruction that was given was the 2011 instruction. It's the exact same instruction that was in Pearson. So I think trial strategy and I can't even imagine why you would have a trial strategy that would allow the state to not prove an important element of the crime that makes that crime different from other crimes. And even though in this case it does, with the prejudice, it just seems fundamentally unfair of us to allow the court or the juror, or the state's asking us to presume an element of this crime. And I think that's going down a dangerous road, regardless of if it's a Strickland standard, a structural standard, or presumed prejudice standard. The court has a duty to properly instruct the jury. I wish counsel had objected to.
But defense attorney has an obligation to protect his client's interest.
Absolutely.
I mean, the court is not, the court can only do so much, but if you don't object to the case, and, I have the same concerns Justice Mansfield has, is that, you don't bring an error to the attention of the court and then go through this whole trial, and all of a sudden you get a freebie, and that's not right either.
Well, no, and yeah, counsel had a duty to object. That's how our law is with regard to jury instructions, that it's not preserved. And so, yes, we do have to go under a Strickland standard and ineffective assistance of counsel framework. And there was obviously error for counsel failing to object to this obviously wrong jury instruction. And whatever prejudice standard we apply, I think in this case, we do have prejudice. We would ask the court for those reasons to reverse. Thank you very much.
Thank you as well, Ms. Ruhtenberg.
Merry Christmas.
Thank you. State of Iowa versus Harris is now then submitted, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.